today's session of SMS. So we have with us Sri Abhishek Agarwalji from the city of Joy, Kolkata. You can see joy on his face also always. So, so he's like a younger brother to me, and with around more than 13 years of experience discussing about GST and indirect tax on different forums like ICAI, DTPA, and other national level organizations also. So, and he also trained professionals, government officers, and apart from the trade also. And so, with this brief, I think introduction, I would request Abhishek ji to take the deliberations forward.
Thank you so much, sir. Uh, Firstly, a warm morning to everyone. Uh, Thanks to Arupda.
अभिषेक जी
Thanks
थोड़ा
to.
लाउड थोड़ा वॉल्यूम थोड़ा बढ़ाना पड़ेगा.
I'm audible wrong?
Yeah, you're audible. वॉल्यूम थोड़ा बढ़ाना पड़ेगा बस. ठीक.
Oh, now it's better. Now it's better.
Yeah, now it's
Okay.
better.
Okay. So, firstly, thank you to Arupda and Venu, sir, giving me a call and asking me, you don't have option, you have to come tomorrow morning. I'm like, okay. So, friends, I will share the same slide which I shared yesterday in the group, and I've noted few pointers for each change, and we can discuss. I know, sir, I have to be allowed to share the screen.
कर
Done,
दिया.
sir.
हाँ.
Oh, thank you so much, sir. Yeah. Is my screen is visible?
Yes, it's
Okay.
coming.
It's visible, right?
So it's just appearing. It's not stop appeared, but it's appearing. आ गया.
Okay. Okay. Just give me. Perfect. So, perfect. So I will start with the straight away the first change, and that is in Rule 2F. So, friends, this is with respect to certified copies. A lot of people were doing a lot of things, and they have strictly changed two things in this particular rule. Number one, they have mentioned that it was earlier that it was only a department. They specified that officer of the department that was deemed definitely, but again they have specified it is an officer of the department. Now, if we go on a more deep reading, we need to understand which officer. So again, they have defined officer of the department can attest, and second, they have given relaxation on the clarification that let's say a taxpayer wants to file a appeal, and at this moment they don't want to appoint any authorized representative, right? So in that particular case, they did not just unnecessary put a name of the authorized representative, and they can do it themselves. They can attest themselves instead of the AR. So this rule 2F specify this two major changes, which gives us a lot of confidence on this. Currently, I believe everybody is practicing in a different mode. What we are doing, we are taking the printouts, stamp and signing every page, again putting it on a color scan, and then doing pagination. I know that might not be required, but for the safety purpose, we are doing this in our office. Anyone, any views on this rule?
No, Abhishek,
Perfect.
we were already following this only. Whatever they have said, no? Because this was also
Okay.
clarified by the president earlier. So I think many
Right,
of
sir.
us were following this.
Right, sir.
So any other view
Perfect.
of the house? Anyone wants to say on this, or we'll go to the next slide? Abhishek, next slide. Chalo.
So 15B, again, it is told that every procedural notification
Sir, all of
from the
us,
registrar
may interrupt a
mandate.
bit, sir. Abhishek ji, all of us,
Suresh,
we
your
need.
voice is very low.
Hello,
Yes, sir. Yes, sir.
बोलिए sir.
my point is that what is this order? Order is DRC07 plus that order, speaking order by the officer, by the applicant, or APL04.
So
So
that we are
order
getting a
is
clarification.
what
So
order?
that we are getting a clarification, a subsequent amendment. They
Okay.
have tried to clarify it, but I'll point out they ended up creating more confusion
Hmm.
in OIO versus OIA.
Hmm. No,
So
OIO and OIA, there are two things. One is the summary of the order and one is the order. So when they talk of certificate copy of order, if uploaded in the, because yesterday I was filing an appeal, there was only APL04 was appearing. Order was not appearing in that GStat portal. So what it means, we have to certify that order no, because in GStat portal, you can check the order appealed against to confirm it. And I think it is the first or second para. So when we opened that PDF file, it was only APL04. So not the speaking order. So I want the view of the house in that, sir.
sir,
Yeah, anybody in the house wants to say on this? So primarily two questions are asked by Malhotra sir. One, what does this original copy of the order mean? Is it order in original or order in appeal? Two, if the order in original is uploaded, but say DRC07 is only uploaded, the detailed order is not uploaded. So in that case, what would be the scenario? That whether DRC07 need not be signed again, but yes, the detailed order, since it's not there uploaded on the portal, that needs to be signed by the appellant.
Arudha, in Rule 21.1, the next slide of this, have a
Yes.
clarification connected to this. Suresh, if you
No,
tell me
that is regarding the uploading. That is regarding the uploading of the document.
right,
His question is on two parts. On one part is that whether order in original, I think for the I think original order of the copy of the order would be both.
Question, one part is not there at all. We know what is OIA, what is OIA. That is no problem. Only thing is that because if uploaded, they have used the word uploaded in the portal. So in GStat,
Yes.
only APL04 is appearing, speaking order is not appearing. But my humble view is that order means speaking order. Because that
Sir,
is
order is OIO and OIA. DRC07 or APL04 is merely a summary of the order.
That is my point, sir. That is my point.
Right,
So
sir. This has to be.
that summary is appearing in the GStat portal. That is, they are just telling us to confirm it. It is the order. Yes, that is the order. But where is the order? Order is not appearing. So whether we have to file the certificate copy or not.
But Malhotra sir, I think as Abhishek was saying, we'll go to Rule 21 and then we'll come back to this question. But about the uploaded in the common portal of GST, not GStat. So I think we'll go to 21 and then come back to this question of yours.
Suresh, permissible?
Yes.
Yes. Okay. Okay. So 15B, this is again a small change, but a very important. It says that whatever procedural notification which registrar will give will be coming from a formal direction or instruction from the tribunal bench. So this will not happen ki registrar will give whatever he want. It has to route it through that bench only. So let's say a particular registrar in Kolkata wants something in a particular fashion versus a particular registrar in Bangalore wants something in a different fashion. So that thing need to be routed through the bench members. Okay. Now I'm going to Rule 21, Sub-Rule 1. If you see the changes, it is very much specific. So I will take you to the change first. Every form of the appeal required to be heard by the appellate tribunal shall be accompanied by a certified copy of the order appealed against, that is OIA, and order of original adjudicating authority, that is OIO, along with all documents, including relied upon documents, provided ... The second proviso which they have inserted is provided that where order appealed against is uploaded on the common portal. It's not talking about DRC07 or APL04. It is where order appealed against is uploaded in the common portal, then certified copy of the order appealed against may not be accompanied. They are not talking about anything about OIO. They are only giving a relaxation in OIA in this proviso that where order appealed against is uploaded in the common portal, then there is no required of certified copy of the same. So This is the relaxation which they have given. So, Suresh, coming back to your question, to me, you need to arrange the certified copy. Since OIA is not there in the portal.
Technically, sir,
Abhishek, the question here is whether uploaded on the common portal, it will be the GST portal, right? Not GSTAT. The sir is
The
saying,
gst.gov.in, APL04 has to be there, no?
common
so sir
portal
is
means
saying कि
just-
GSTAT में appear नहीं कर रहा है.
that is good. So, point is that, sir, no, this says, no, we need not to file OIA, what I need, what I feel. OIA is not to be tied with the appeal, not to be filed, or certificate copy is not to be filed. You know, there are 2 points to it. I think for our paper book, OIA must be there, it must be there. Right? So they are saying that they are saying that certificate copy of the order appealed against may not be combined. So it means they are saying that it may or may not be, you know.
Sir,
It is
may not be accompanied only when it is uploaded already uploaded on the common portal.
90% of the orders are uploaded, sir. 90% of the orders
Right,
are
sir.
uploaded in the common
Right,
portal. So we technically we need not to file that along with the appeal. This is about their version. But in our paper book, we will be filing it because it is a main document for us.
Indeed, sir. Indeed, sir. I second with your opinion, sir.
So good morning to all of you. So Sarvan Prabhu here. So I will, am I audible?
Sir, sir,
Yeah.
you are not audible.
Yeah.
You are audible, yeah.
Right. So probably I was a little intimately involved with all these changes in the procedure rules per se. So therefore, I will probably throw light on the thought process as to why this particular amendments were made. If you can give me a
Yes.
couple of minutes time. So the amendment was predominantly visualized in Rule 21 only. So if you see Rule 21, 21 sub-rule 1 is completely unnecessary. If you see 21 sub-rule 1, it says where an appeal is preferred against an order in original itself. So therefore, there is no question of any direct appeal against an order in original. There are only 2 appeals possible at the GSTAT. One is 107 order, other is 108 review order. So there is no question of any adjudication order being directly appealed to GSTAT. This was the primary problem in 21 sub-rule 1. The second problem was, as all of you know, August 2023, even for first appeal, where the certified copy was already, where the copy of the order was already served on the portal, then the requirement of filing the certified copies were dispensed off with the first appeal. I'm saying 2023 August. So the question was, why can't the same thing be adopted for GSTAT also? So this was the 2 thought process. So one, Rule 21, 1 by itself had some flaws. Second is the requirement of certified copy, which was not there for first appeal, pursuant to August 2023 amendments. Why shouldn't the same thing be extended to GSTAT also? Because already we have the orders uploaded on the portal. So to carry out these 2 amendments only, the Rule 21 was sought to be recast to one, remove the anomaly, and second is to say that where the copy is already there in the portal, why again give a certified copy again? That is absolutely not required. So to align with the first appeal process. Incidentally, what is certified copy? That definition, Rule 2F is there. That also probably needed a revisit. So we went from Rule 21 and then we went back to Rule 2F because certified copy was there. Now we had to see what certified copy was. Rule 2F is largely borrowed from STAT procedure rules only, largely. So therefore, there we saw that everywhere now the thought process of the department is that certified means it can be either self-certified by the appellant himself or it can be certified by the authorized representative. So that language should also be brought in Rule 2F. Or if it is a departmental order, it was mentioning that the department should authenticate. Where is the question of department authenticating? Some person in the department only should authenticate. Therefore, an officer of the concerned department, so those reference to a particular person was given. But of course, see, we have given our inputs, but the drafting needs a little bit more fine-tuning. But this is the thought process behind which this Rule 21 and consequently Rule 2F was also amended. So views of the House I'll take on.
Fine, sir. Thank you so much for insights. Yes. So we'll move further. Okay, this nothing great. They have only done the grammatical tweak. They have inserted under the instead of the. So no impact as such. Okay. So in this particular attestation, also they have not done any changes. It is only decided that no amendment is required. They have received the representation, but they have decided not to change anything. 21.6, again a small change that tagged firmly word has been indicating the physical filing and all that stuff. So they have replaced this with a line furnish online duly signed or verified through electronic verification code. So all relevant documents need to be done pagination, and my sir is there. Use the tool and do the needful. So
Sir, one question, sir, Abhishek ji. Yes, I just wanted to confirm.
so can you be a bit louder, sir? Your voice is.
Oh, yes, a minute. I will be louder, sir. Actually, my point is that if we verified by EBC, so is DSC compulsory or EBC can do the things?
Okay, so we are discussing the rule now. The portal, to my limited understanding, gives three things: offline physical signature, offline DSC, online DSC. So whenever we upload a document in a portal, that is an online DSC we have to attach. Offline DSC is attaching signature in the PDFs. So that can be done through EVC. So currently we are using DG Locker, e-Hastakshar.
Okay.
Currently we are using this DG Locker facility, e-Hastakshar, through OTP. So the electronic verification code, if you go and search, it is through OTP only.
Okay. So,
So
then sir, DSC is not compulsory. That I just wanted to confirm this.
sir, DSC is compulsory for the purpose of filing in the portal, and you, instead of this electronic verification code, you can also use again a DSC to sign the PDF. So two different things we're talking about. Signing the paper and putting a DSC online when we are filing, uploading the appeal. Those two different things. So this is with respect to the first thing, signing each and every paper. You can do digitally.
Signing can be done physically also, and it can be scanned. Okay, that is clear. Okay, one thing is there. So we don't require DSC there. That is clear.
Sir, as per instruction 29 instruction on the portal, it says physically also, it says digitally also.
Both.
Right, sir. To my understanding, the 29 instructions of the GST portal, they have two separate questions. In one, there I ask, have you signed physically? In the another question they ask, have you filed it digitally?
Okay,
no. Signature can be either physically or digitally. Signature can be either.
Abhishek, just simple question. Can I file appeal without having DSC?
Sir, we are doing that.
Yes.
We are doing it, sir.
I think that was the question by Malhotra.
Yeah, Suresh. Yeah, yes. Yeah, Malhotra sir.
File it, sir.
We can do
file it through DSC.
Sir, pardon?
You can file it through DSC. You can also file it through EBC, sir. Both options are there.
Always.
So
अभी मल्होत्रा सर EBC में क्या प्रॉब्लम आ रही है हम बताते हैं आपको. आधार बेस तो EBC वो नहीं आ रही है, तो इसलिए हम लोग DSC से कर रहे हैं.
नहीं 2 मिनट सर, 2 मिनट. अरूपदा, अब क्वेश्चन ये आ गया कि अगर हमने फिजिकली साइन करें या DSC साइन करें डॉक्यूमेंट जो हमने स्कैन करने हैं अपलोड करने के लिए, तो दैट कैन बी आइदर फिजिकली और थ्रू DSC as
yes.
Arupda told.
Yes.
And second point is that for filing, for uploading the appeal, we don't need DSC. Basically, my question was that either a person required DSC or not. I think it must not require.
No, it is optional.
Alternatively, without DSC also you can file, sir. Yes.
Thank you.
Yeah. Okay. Now coming to the Rule 22, in this a note is added, and the note says that one sign by the applicant and one identification of the professional will solve the purpose. So it is endorsement and verification. Earlier it was told that in at every foot of every page, signature need to be done. So instead, keeping that provision intact, they have inserted a note for the purpose of the preferring an appeal, filing an appeal properly. One verification of the appellant containing the statement that the contents of the statement of facts, ground of appeal, and annexures filed as documents are true and correct to his best knowledge, belief, and information. With after signing this, you also the identification of the advocate, tax professional also need to be done.
Sir,
So this is
I think it is there is an affidavit also which is to be filed. I think it is on the same thing only, affidavit. No, that affidavit will not be required, sir, because normally we file an affidavit in High Court or here also there was a pro forma shared in our faculty group that the affidavit is to be filed. So, sir, that if with this authentication or are we required to file affidavit also or not? That is exempted.
so to my understanding, no.
No, that's correct.
Malhotra sir, through the instruction issued in March and again reiterated 14th May 2026, it has been reiterated that there are a set of documents which need to be filed, and affidavit is not one of them.
Right.
Affidavit can be
Affidavit has
filed.
to be filed.
Yeah,
Affidavit.
affidavit can be filed if you are filing in support of some evidence that you want to give evidentiary value. But affidavit per se for the filing appeal, that has been done away with till 31st of December 2026. Now we need to see what the instructions will come after that. But till 31st December 2026, affidavit is not a mandatory document. And as Abhishek ji has rightly pointed out, why this was brought in, because हम एक सेमिनार में गए थे, वहां पे हम लोगों का 10 मिनट का यही चर्चा चला कि एपिलेंट हर पन्ने पे कैसे साइन करेगा, इतना बड़ा बड़ा अपील बन रहा है, इतने रिलायड अपन डॉक्यूमेंट्स हैं, तो कैसे वो साइन करेगा, 700 पन्ने का वो अपील है तो कैसे साइन करेगा. तो दिस इज solution to that particular question कि सर आपको हर पन्ने पे साइन नहीं करने से भी चलेगा. You sign in the verification saying that all these documents, the contents of the statement of fact, grounds of appeal, annexures filed as documents are true and correct to his best knowledge. So जो भी आप कर रहे हो, you are certifying that all the documents are duly verified by you. So एक verification से वो that purpose has been achieved. That's it. Because this was the last question asked by the trade.
Sir,
Yes,
yesterday,
thank you, Aman.
One more connected question.
मनोज जी उसके पहले एक बार माइनर जी के पास जाते हैं. Just एक second.
Sir, yesterday we had session with the president. Even he clarified 2-3 things. One, the board resolution is also not required if he is already registered
The
in
authorized
the
signatory.
portal, authorized signatory. So even in the company's board resolution not required, affidavit not required, and at the end he was saying APL 5 one place you sign and upload all the attachments. If the other party objects we see, otherwise that is more than sufficient. We will not raise any defect. If that basic document which we requested, if it is there in the portal, even without signature, only APL file is signed, it's more than enough what they finally took.
Yes.
And they said last page, if it is signed, it is fine. That's what he was mentioning.
Last page of APL file.
Yeah, last page would be the verification page.
That's sufficient enough, he was saying. It's not that all the pages.
Because you are hereby certifying everything. You are saying yourself that
Yes.
everything you are certifying to be true.
Sir, here what do we mean by with an identification by an advocate, by the advocate or tax professional? What do we mean by in APL 5? In table number 12, we write the name of the advocate and that's it?
No. Abhishek ji, what happens is typically this, as I have said in multiple seminars and webinars, most of our GSTAT rules have been copy pasted from High Court rules. ठीक है, काफी जगह में आपको मिलेगा. So this also identification is there in the High Court rules where they say any verification filed by the writ petitioner, it has to be identified by the advocate. So what do we identify? We identify that this person who is signing, he is signing in my presence.
That's it.
Okay.
So after
So
signature,
that
if
same
an advocate, right, identified by in front of me, that's it.
Identified by me and the advocate will sign. That's it.
The table 12, that is a AR, could be the company itself. While filing
they may not have an AR also. Yes,
Right.
they may not have an AR also.
Right.
And we now go to Abhishek. You will go to Malhotra sir's question.
Yes, sir.
He had a question. Yeah, Malhotra.
My point is that in CSTAT, when I file my power of attorney as a chartered accountant,
Yes, sir.
because we are chartered accountant, there is a bit difference. So I file it on an affidavit, on a stamp paper. on a stamp paper of rupees 50 or 100.
Yes.
In C-stat, in G-stat also, I think that will be doing, we will be filing a power of attorney on the affidavit or on the stamp paper. That is my question.
You're saying the authorization for a chartered accountant, right?
Yes.
Yeah, that has to be as per the local Stamp Act, sir. As per
That
the
has to
Stamp
be,
Act of the
I
relevant
think,
state.
I think stamp has to be earlier, but I was doing for C-stat, the same will be doing here.
Yes, sir. That is as per the local Stamp Act of the state.
Yeah, across the
Whatever.
country, wherever we are filing affidavits, we are doing in a local state stamp.
No,
paper.
not affidavit, not affidavit. Abhishek ji, he's talking about the authorization.
Authorization.
Chartered accountant
Authorization.
authorization. Advocate authorization can be on a plain paper.
Wakalatnama. We get the
Wakalatnama,
authorization on a wakalatnama. Yes.
But CA's has to be filed on a stamp paper. That is my point.
On authorization, yes.
Thank you, sir. Thank you.
Okay. So let's go to 23, the translation of documents. Again, very mischievously they have done this. Rule 23 is defined. Sub-rule 2, they proposed to remove and insert a proviso, provided that the bench in its own discretion may relax the aforesaid requirement. It is further resolved that sub-rule 2 may be omitted. Now my question is, once it is omitted altogether, then there will be no binding to put a translation. Okay, let's see. So so this is the changes which they have mentioned, that it will be the discretion of the bench. That let's say both the bench member or all the bench members are comfortable with the Gujarati order or a local language order, then it's fine. Okay. So the next rule is
No,
rule
Abhishek ji, before moving to any other questions from the house on this translation. तो
please,
ये एक
please.
बड़ा मुद्दा था, कैसे कर रहे हैं, क्या कर रहे हैं, साइन लगेगा, नहीं लगेगा. तो उस पे any questions from the house on this, or any inputs rather, not questions.
Any view?
Inputs.
Yes.
Yes. Anybody?
I think yesterday the president has also confirmed that if both the members or whoever the members sitting there, if they are comfortable with the local language, then there is no need
Yes.
to have the translation. The bench will decide it discretionary, and the process they have given is like they will get the translation done and it will be confirmed by the next party.
Yes.
And if you are okay with that, then they can go with this.
Okay. This process is not defined, sir. They have told verbally.
No. This is already there in the rule. See, it is said the first leg, if you read, which is agreed to by both the parties. A document, if you see the change provision, a document other than English language intended to be used in any proceeding before the appellate tribunal shall be received by the registrar accompanied by a translated copy in English. First leg is which is agreed to by both the parties. Second leg said about certified true translate copy. So if Mia Bibi Raji, to kya karega Kaji?
Arudha, so let's say I have an order in UP in Hindi.
Yes.
So I am filing, and the bench member said, no, I'm comfortable only in English. So it's the burden is on me to translate in English.
Yes.
And it has to be
And if that is
agreed by
approved,
the respondent.
yes. उन्होंने अगर मान लिया तो ठीक है, अगर नहीं मानते ठीक है. So there could be two situations. One, the bench itself, till both the members are comfortable with the local language, they do everything. Why we say both the members? Because in case of central tax, it can happen that somebody from one part of the country is traveling to another part of the country, they may not be comfortable with that language if that technical member is there. So in that case, both the members may not be comfortable. So in that case, there will be a blanket thing कि भाई translation देना पड़ेगा. So in that translation कैसे करेंगे? हम लोग translate करके देंगे और अगला जो है वो अगर मान लेते, if they agree, then it's okay. अगर नहीं मानता है तो फिर they'll raise an objection. We'll have to rectify the translation. So that is how it will work. But वो जो certified copy and all those things, that has to be worked out later on.
If the objection is there,
Yes.
then we have to provide a certified copy.
Right, sir.
Yes.
Arudha, can we ask the other party to give us the English translated rather than we translating?
वो देंगे ना, जब वो डिपार्टमेंट अपील फाइल करेंगे, they'll give the translation. हम चेक करेंगे.
So, sir, we got a Uttarakhand order in Hindi, and the Hindi was so pure Hindi that I need to go to my dad and understood the meaning of this.
Same with Bihar orders. The terms also we don't understand. I am conversant in Hindi, but I myself
you
don't
are
understand. Yeah. So क्या लिखा है that I can't understand. So anyways.
Done,
Do
sir.
you know the meaning of bijak? It is invoice. That's what is written in the show cause notice in Chhattisgarh.
Sir,
Digital.
बताइए.
sir, Arup sir, one question, sir. Arup sir,
Yes, sir. Paul, sir, please, sir.
yes, sir.
Yes, sir. Yes, sir.
Sir, it is bench at discretion. It is they will ask at the time of hearing or at the time of filing. So when they can give the exercise the discretion, sir.
My understanding is, sir, they'll give a relaxation to the registrar itself to accept on this basis. The
Okay,
bench
sir.
will take a pre-decision on this. That,
Okay,
for
sir.
all appeals filed till from this date to this date, whatever, till further notice, no translation is required. If it is
Bec-
in Hindi or whatever the local language, Gujarati or Bengali, local languages.
Because at the time of filing, a person knowing Tamil will be sitting, but at the time of hearing, a person knows only Hindi will be sitting. So
Yes.
I think when the
Yes.
relaxation will be there. That's the thing.
Also, you have rightly pointed out. So that was also raised in one of the seminars that ठीक है, translation कैसा तो क्या होगा? But I think that as GST, in GST we have learned that पहले execution हो जाएगा, फिर correction होगा. So now we'll do with it. So at the time of hearing, if there is a new bench, maybe they'll request for a translation.
Thank you. Okay, thank you, sir.
Done, sir. We'll move further. So, Rule 24. So, it is giving endorsement and scrutiny of petition or appeal or a document. So, the relaxation is from 7 days to 15 days and further 30 days to 45 days. So, whatever the registrar, if notice or any defects is there, it is need to be communicated in 15 days, which it was earlier 7 days. And the maximum time was earlier 30 days, which got extended to 45 days. Two more things which they have endorsed. One, the defects need to be communicated in writing, not verbal. And the third and most important, that it has to be in GST80 portal. Abhi mail aa gaya, phone aa gaya, but now they have to be recorded in portal in writing, and the days have been extended, relaxed from 7 days to 15 days. But sir, अभी हो तो नहीं रहा 15 दिन में. मेरे कुछ अपील फाइल हुए 1 महीना हो गया ऑलमोस्ट 22-23 दिन हो गए और अभी तक कोई डिफेक्ट्स नहीं आया और आई एम श्योर कि डिफेक्ट्स होंगे. आई एम वेरी कॉन्फिडेंट कि
In
डिफेक्ट्स
my case, sir, received and
Is it?
filed the defect reply also. We did.
चलिए
So we
रामनदीप
got-
जी के लिए हाथ तालिए.
Sir, we got a case where
कि आपको डिफेक्ट मिल गया एटलीस्ट.
sir, we got a case where a department came for appeal and our client is a respondent. So there we can see all those things. But again, अभी तक मेरे ही फाइल किए हुए केस में डिफेक्ट्स तो नहीं आए. Okay. So, sir, if you read the word again here, then the registrar shall issue. So my whole point was that this only, that since they don't issue, it's a rule, yes, but if they're not issuing, it means that there is no defects. Will it be binding that way?
I think if they give the acknowledgement, that would be a sufficient proof that there are no defects.
Because reading this with the rules of the GST Act, what they say is ki APL 02A Part A will be generated as soon as you file it.
Yes.
Once you clarify and it's a defect free, then only Part B is generated, and the date of APL 2A Part A will be deemed to be date of the filing.
Yes.
But if you don't clarify within the prescribed limits, then a new number will be allotted, and the second date will be the date of the filing. So this shall need to be read as shall, I believe. But again, that's I wanted to bring into the house.
हाँ, मतलब अगर कोई डिफेक्ट नहीं है तो नहीं इशू करेंगे.
हाँ, नहीं वो
They'll
ठीक है,
give the
but
part B.
आज जैसे 20 to 25 days हो रहे हैं. I'm sure across the country defects बहुत कम ही आ रहे हैं. Ramandeep sir is very lucky of us कि he got the defects. But my point is कि अगर जो नहीं आ रहे, इसका मतलब क्या और वो डिफेक्ट नहीं आएगा या रेज नहीं
नहीं,
कर
it is
सकता?
not like no news is good news. Some news is good news.
No, Abhishek's point maybe can it be said as deemed acceptance?
हाँ,
Is
right,
that a
sir.
point?
My point is it deemed acceptance?
No, I don't think it will be possible.
Huh.
Because the wordings are not that, because in GST we have 7510 where it says if the notice is not issued, it is deemed to be concluded. All that positive words are not there to say it is deemed to be accepted. So whenever there is no consequences, it's discretionary, even the word uses shall.
And when it said that the positive act of giving a part B is said to be acknowledgement, I think without getting that, it cannot be said that it is already accepted. That is also one thing.
Okay. So any other view on this we want to discuss, or we can move further?
नहीं? Any other views of the house on this? नहीं, चलिए move करते हैं.
Done, sir. So again, it's ex parte amendment. They have streamlined or removed the vague part or such other errors. So they've removed that, and they've ensured that if it is application is arithmetical, grammatical, or clerical, then only it will be ex parte clarifications, amendments. They will do it without the party. So that's it. Nothing that great. We'll move further. Interlocutory application. Bit of drafting change and bit of new things came up. So if you see the first line, every interlocutory application for state direction, ... how they have redrafted this, an interlocutory application can be filed only. So now this is not exhaust. Now this is limited. It's not example, it's limited for all these things. Only for state direction notification, they have added restoration or other interim prayers. And the one proviso has got inserted, proviso for adjournment of hearing, the date of appeals or application listed. The filing of interlocutory application is not mandatory. So when we request for adjournment, we don't need to do it through an IA. So this 3 changes. One is only one inserted. Second is restoration or other interim prayers took a place in this provision, and a clarification that IA is no longer required to seek adjournments. In this particular rule,
अभिषेक जी, इसमें एक्चुअली क्यों करना पड़ा? क्योंकि काफी अपील्स जो है डिसमिस हो सकता है for default for not attending the hearing. So that's why this was raised by the trade. This query was raised by the trade. क्या dismiss for default होता है? Then how do we restore it? Because IA provisions do not have it explicitly, but कर तो सकते हैं. That is, it is there, but it's not in a pending. So that's why they said, एक बार अगर dismiss हो जाता है, then it is not a pending matter. So that's why this clarification come for restoration. Now regarding the adjournment, there was a huge hue and cry कि adjournment के लिए भी IA फाइल करना पड़ेगा, 5,000 रुपया देना पड़ेगा. तो application फाइल करना पड़ेगा, that was not a problem. 5,000 रुपया देना पड़ेगा, that was a huge thing.
That is a problem. Indeed, sir.
So that was written in many forums, I think, and that's why they clarified कि नहीं भाई, adjournment के लिए कुछ नहीं करना पड़ेगा. It's like previously only. Just आप जाओ, मांगो, मेल भेजो, जो भी करना है communication करो, but नहीं लगे.
So Arup sir, अभी I've been regularly visiting the GSTAT bench, Kolkata, whatever happening. So 90% cases are filed by the department.
Till now.
Respondents are not even informed. They are celebrating that APL4 received order in their favor, and they are not even having any clue that उनके gst.gov.in में जो order है, उसके against में GST 80 में appeal file हो गया. So Abhi Sandeep sir was fighting a case last week, and I was there. So we presented the principal bench judgment, ANT Securities, 18th May, that 169 need to be followed, and a physical delivery of the letters need to be communicated. So this, if point can be taken by us everywhere across and represented, is a very important thing, because
this has already been presented. This has already been represented, but इसमें problem क्या बताता हूँ? 169 is being followed, but here what they have defined is the common portal for GST80 is the GST80 site website. So what they are doing is right, they are putting it in GST80. अब मेरे लिए responsibility बनता है कि मैं हर tax payer का registration करवाऊं. वो जाके देखेगा कि मेरे अगेंस्ट में कोई अगर APL 04 मेरे फेवर में है.
9 साल में I know Arup sir have got 1000 APL4 favor in favor to the SEC. So is it possible for you to have 1000 GST registrations?
They are expecting us to go in. That's why it is being said that for all these departmental appeals, we should have a receiver made.
Indeed, sir. Done. So I'll move forward.
Sir, and also yesterday they clarified they will try uploading in the portal. If not, they will again they do email. If not, again they will send physical. So they will ensure that all 3 modes are used and it is communicated. Then only they will take any adverse action. Till that they will not take any adverse action. They will try to if there is no response from the assessee, then they go to other modes. If there is a response,
Yes.
then there is a proof of communication. They will stop.
Right. Yeah, that has been the thought across the different forums by the Honorable GStat. So I think that's a good thing because it's not possible. Mails, maybe, yeah, we can get it, then maybe we'll be able to attend. And also physical also in some cases. Yeah, Abhishek ji.
So Rule 35 again, a mere drafting correction. They have replaced the words reply to appeals or application has been replaced with replies to application because it's a cross objection to appeals and reply to applications. So nothing further. 36. Okay. Filing of reply and other documents by the respondents. So in this, the bench may extend the time. So respondent need to reply within 30 days. So this has been specified that within such time as may be specified or extended by the bench. So this relaxation has been inserted. So the 1 month period of filing appeal was a hard limit under the old rule. The amendment gives benches express power to extend this wherever needed. So any respondent, the department or SSC, whosoever is the respondent, can get pray for extension to the bench. Anything further to discuss? Any points?
Oh, I think this was required. This was required.
Yes, indeed. Otherwise, it was too fast. Okay.
Should we make any application?
Sir, process is not defined. So yes, indeed, I believe if you want an extension, you need to make an application. And sir, when we read the IA thing, it is covered that adjournment you don't need IA, but for replying back to the bench, yes, you may.
Seeking the extension of time, you need IA.
Yes, sir.
Seeking, yes.
Yes, sir.
Sir, it means this is a provision by which when we file an appeal, department has to file a reply. It is like that. So normally department don't file any reply, they just argue it. They just argue when the hearing comes. So presently in CSTAT, there is no such practice of filing reply by the department, or if it is a department appeal by us. We normally file our additional submissions at the time of hearing only. I think this must be with relation to cross objection if to be filed, I think.
Sir, the next slide, Rule 37 is that only. They have specified that rejoinder is not specifically to the cross objections. So earlier it was reply filed. Earlier it was rejoinder to the reply filed. Now they have drafted that rejoinder to the cross objections filed. They have removed cross reply against the, they have removed rejoinder against the replies.
Correct. But actually my point is that, is it mandatory to file this reply or something? That was my point basically. I don't think it is mandatory. We can straightway argue our case if it is filed by the department. A department, then sir, it means it will be a cumbersome process. When I file an appeal, the department will file a reply, and that copy of reply should come to me also. Presently in CSTAT, I have got 100 of appeals, but there are no such practices there, sir. My point is that this is mandatory or discretionary. That is the only point, sir.
So I think this is the right given to us that we file the cross objections that against the appeal filed by the department. Okay, so if we're foregoing this thing, then maybe we'll miss on representing our matters.
Yes, cross is fine enough, sir. Cross is fine enough. But what about the normal appeals? There is no cross action, sir. That was my point.
Sir, if department is filing an appeal, to my understanding, we are always filing a cross objections.
Yes, always.
No, sir, no. There are 2 points, sir, here. Cross action, what is meant by cross action? Cross action is a thing which we also want to point out in the order which if I have not filed the appeal, I have not preferred the appeal before that. But
Indeed, sir, without pre-deposit, without fees, yes.
Certain points which I want to highlight before the bench. Look, these errors were also there. Okay,
Right, sir.
that is cross action. So
Yes, sir.
that is not a reply. I'm talking of reply to the appeal. What is this? Reply to the appeal. I will argue the case, before that. So
Yeah, reply to the appeal would not be mandatory. You're rightly
that
saying.
was
It
my
would be,
point.
it would be a option on our part.
But
And sir, as rightly
But-
pointed by you, sir, that's the reason they have removed our reply and put the cross objection in Rule 37.
Okay.
yes, sir. Sir, in my opinion, sir, am I audible, sir?
Yes, sir, please.
Yes, sir, yes, sir.
Sir, memorandum of cross objection is to raise a point that we have not raised in the appeal, or when the department fail, we go to that. That's the thing. But the reply is mandatory. If we seek the same similar manner only from the department also, then only we will be able to counter it at the time of hearing, sir, personal hearing, or before the bench we can hear it. Suppose we are filing an appeal, and then department comes with a new aspect or some new angle to that our reply, our grounds of appeal, then we will not be able to suddenly raise that or defend that case.
Yes.
So if we
It will
get
get-
the viewpoints of the department to our appeal, then we can prepare the counter in an effective manner. This is my opinion, sir.
Yes, yes.
Indeed, sir, we all
It's
on the
always
same
wise,
page.
better to file a reply.
Yeah, we all on the same page. So just connecting with this Rule 36 with Rule 37. So what they have changed is where the respondent states such additional facts. Where the respondent states such additional facts as may be necessary for the just decision. So in this particular thing, the rejoinder to the cross objection is to be filed. So a rejoinder is not specifically to the cross objections and not to the reply. So what we just discussed. I will then move to Rule 38. In this, again, a very welcome change they have proposed, and that is like CSTAT we have, they will give a weekly cause list. On Friday, they will give a cause list probably for the next upcoming week, and there will be a supplementary list may be published as it is happening in CSTAT. So this is a welcome thing which happened in the GST 80 cost list also. So next. Okay. New cause list on sitting days. So if a holiday is announced on a pre-decided cause list, then that particular cases need to be shared that when it will be happening. So the word new daily cause list has been removed and new cause list has been replaced. So they will be giving the cause list that where this case will be getting accommodated, to removing the ambiguity in the rule itself, that by the new cause list shall be prepared for the cases listed for the day by suitably incorporating the listed cases for on a subsequent day or days. So nothing as such in this also. Okay. Now this is important. Rectification is a rectification of the order. So a person, if they need to apply, they need to apply in 30 days. A representation was given to extend this. They have not extended this. Why they have not extended this? They have given a reasoning that section 113 subsection 2 give tribunal the power of 3 months to rectify. So they wanted to have this gap of 1 month and 3 months. So they gave this reasoning and they told that we got this representation, but we don't want to extend the time limit for the application of rectification more than 1 month. So this is thing. And the last one is again related to fees that they told that, okay, for rectification, we have got that IT80 and CSTAT fees are less compared to GST 80. So for rectification, there will be no extra fees. So that's it. These were all the changes thing, not that much, but again, I'm glad that I be a part and share this view.
Yes. So we have about 6-7 minutes. So any other inputs, views we want to have from the house?
Will the time limit be extended, sir? 36 time limit.
5,000 rupees condonation,
For the
sir.
answer, after you have to send me some sweets from Chennai, Coimbatore first. Once I get the sweets, then we'll give the answer.
Although your voice is getting cut.
I'm saying for this reply, we need to have sweets from Coimbatore, and only then we will give this answer.
Because Coimbatore is my place, sir. Coimbatore is my place. It will be pleasant to send you all the sweets, sir, if it is extended.
So, in my view, so what we are trying to do, at least from the different forums that we're doing, we are trying to highlight the challenges that we are facing. कि क्या-क्या दिक्कतें आ रही हैं file करने, what are the challenges that we're facing in filing the appeals, and then saying that because of these challenges, ideally the time should be extended. So nobody is saying that time extend kar do, but just because the site is not ready, some are complaining that once you upload all the data on the appeal, still it's getting deleted. Some are saying that name of the AR is getting deleted. So all the multiple issues are there. So because of all this, some are saying in the last moment, some user ID password issues are coming in. So iske liye we are saying that since these technical issues are there, maybe there is extension should be thought by the GSTAT. That's it. Yes.
Yes,
So I
Abhishek,
think
wonderful session. Thank you for the same, Abhishek.
Thank you so
Thank
much.
Last
you,
minute
sir. Thank you.
preparation, last minute it was permitted by the Arup sir. Took up the initiative. Thank you, sir. Thank you.
Thank you so much.
So because bomb gir gaya na, sir, suddenly amendment karta. We thought we'll have a discussion today. A little good for all of us. And then we had this discussion. So abhi, because clients will start calling us, क्या हुआ, उसमें क्या हुआ, उसमें क्या हुआ. So हम लोगों का revision, we had a revision. So I think that is good for us. So if there are no other views, okay. So Annapurna ma'am, you are there?
Yeah, sir.
Also,
Yeah, I'm there, sir.
yeah, ma'am. Can you give a vote of thanks to our beloved
Come on, sir.
Abhishek?
Let me be the student. Annapurna ma'am is what?
नहीं,
No,
नहीं,
She's
no,
school
today
में
you
नहीं
are the
है, करना
master.
पड़ता है.
Today you are the master of vineyards.
Not at all.
Yes.
Very well done. And that was the need of the day, like this changes discussion, in-depth discussion was quite interesting, and it got connected with many practical issues which we are facing day to day, I think, and we will be expecting more such kind of minutes and clarification in this GSTAT procedure. And one aspect is, I think still I believe that GST will override the GSTAT. So I think most of them are concentrating on those procedures. In addition to that, I think we should also look the certain technicalities in the GST law also. And one of the clarification, I think last clarification which they have said that as it is always already mentioned in the GST law regarding rectification that there will be no further court fees. So accordingly, GSTAT procedure also has been amended. So with this, it was quite interesting, quite informative, and thank you all the leading this session in one day, and thank you Arup sir and all the participants and making this session quite interactive and informative. Thank you for this. Thank you once again.
Thank you so much, ma'am. Thank you
So
so
thank you,
much.
Abhishek ji. Thank you
Thank you,
everyone for
Abhishek.
joining. And
Thank you, sir.
Thank you so much.
Thank you.
so
Bye.
next 2 weeks we have break. Next week and next to next we are going to Chennai
Unless-
for PCS RRC.
Unless new bomb is
Hoping
there.
to meet many of you there.
The disclaimer, unless new amendment comes in.
फिर से अभिषेक करना पड़ेगा. फिर से अभिषेक करना पड़ेगा. चलो. Abhishek.
करना पड़ेगा.
Abhishek is not amendment. Let not Abhishek be amendment.
Of knowledge. Chalo, फिर thank you.
Abhishek is already he will have insider information.
And the name of
Before, as soon as it is
the
signed.
informer is Mylar.
Huh?
ठीक है, चलो, thank you.
Thank you
Have a wonderful
Anand.
week.
Thank you so much.
Yeah,
Bye.
thank you.
Bye.